Go ahead, George.
Okay, so the current time is 10:04 a.m. Meeting will come to order. Janelle, do you want to call the roll?
Yes. Alano,
Present.
Bennett, Bennett, Pamela Bennett, Jenkins, absent. Glory,
Present.
Ruckert,
Present.
Sermitis.
Present.
We have quorum.
Okay. So a few reminders as required by the Bagley-Keene Open Meeting Act, members are to appear visibly on camera during the teleconference meetings unless a member is unable to appear by video. Due to issues with connectivity. We ask that any members that are present with their cameras off state their name and reasons for not being on camera. And if a member joins the meeting after roll call, they should raise their hand virtually to notify us of your presence. If their camera is off, please provide an explanation. And we also ask that you raise your hands when leaving or returning to the meeting if you're going to be gone for like more than 5 minutes. Next on the agenda is a call for public comment. Before we begin public comment, I'd like to remind everyone that under the Bagley-Keene Open Meeting Act, public comments must pertain to the items that are on the agenda or be related to matters within the jurisdiction of this agency. Specifically, the committee exercises oversight over the legal specialization program. Members of the public wishing to comment were encouraged to submit written comments prior to the meeting to ensure that the committee would have time to consider those comments. Janelle, I didn't see any written comments.
I would like to state for the record, Pamela Bennett at 10:06 has come to the meeting.
Okay.
We do not have any previous signups. I'm unsure if there are any people located at your agenda's size locations, but I do have two hands raised in the waiting room.
Okay.
The first, go ahead.
Go ahead.
Adrian, are you ready for that?
Mhm. Okay.
Give me one moment.
uh,
Go ahead and finish your script. I'm sorry, George.
Oh, that's okay. To facilitate hearings, as many members of the public as possible, I encourage people not to repeat points made by previous speakers. As chair of the CBLS, I'm going to exercise the option to limit each speaker's time to 2 minutes. For those participating by Zoom video, you should have a function to virtually raise your hand. It's a hand icon and should appear at the bottom center of your screen. And if you wish to address the committee, please click on the hand icon now, and the committee coordinator will call you in the order that hands are raised. For those participating by phone, you may virtually raise your hand by pressing *9. That's the star key, then the number 9. And again, doing so will alert the staff that you would like to make a comment, and the committee coordinator will call on you and open your microphone. If you're participating from a notice location, please alert the committee members of the State Bar, a staff member present in the room that you'd like to make a comment. And staff there will be an on-screen countdown timer visible to all attendees during the duration of your comment. The timer's 2-minute countdown will begin as soon as you start your comment, and the timer will flash throughout the final 10 seconds. Do we have anyone that wishes to make a comment?
I have two hands raised. We're going to go ahead and call first Mr. Kai On. Go ahead, your microphone has been enabled.
Good morning. My name is Kai Om from Sacramento. Political power is controlling State Bar of California, Chief Justice, and Attorney General. Not to investigate Sacramento DA office and SPD make up a story that fake killer Mr. Junso from Hit and Run kill my father won't count on. DA case number 99F0X75. I went
Mr.
to
Otis,
State California office in Sacramento, but governor's office doesn't take any action. How a state government allow political power to control the government, law
could you
enforcement, and justice system to commit obstruction of justice. It needs all members of State Bar, Board of Trustees, and other committee members to speed up and notify California Senate and Assembly to look into the issue. Someone is trying to control State Bar to commit obstruction of justice. Thank you.
Are there additional public comments?
Yes, I have Ted Merman. One moment. Your microphone has been enabled. Ted, your microphone has been enabled. I went ahead and removed his enabled to leave public comment. I allowed him to talk and he didn't say anything. Ted, I'm going to allow you to speak one more time. Ted, your microphone has been enabled. It looks like it concludes public comment.
Yeah. So I'm going to move on to the oral report. This is the third CBLS meeting of the State Bar year. The appointment period for members is closed, and a total of 3 applicants have submitted applications for the 2 available CBLS seats. I will be continuing as a member of the CBLS into next year when my appointment period ends. Damon has submitted a statement of interest to serve as chair, and Dana has submitted a statement of interest to serve as vice chair, each one for a 1-year term. And these appointments are currently pending approval by the Board of Trustees at its July meeting. And after that and appointments, and they'll be moving into those roles. I'm going to move on to approval of the March 20th, 2026 CBLS open meeting minutes. Does anyone need time to review those? Okay. Are there any questions? Okay. I'm going to call for a motion to approve the minutes. Does anyone wish to make a motion?
I'll go ahead and move to approve the March 2026 meeting minutes.
Okay. And is there a second?
Seconded.
Okay.
All right. Alano,
Yes.
Bennett,
Approve.
Jenkins, absent. McGlory,
Approve.
Ruckert-Resman. I didn't hear you. I'm sorry.
I wasn't present, so I abstain.
Okay, perfect. Thank you. And Sir Midas.
Approve.
With 4 yeas and 0 nays, the motion passes.
Right. So our next item on the agenda is the staff report on recent developments regarding the State Bar and the Legal Specialization Program. And Adrian will be leading this.
Sure. Good morning, everybody. Janelle, can you go to the next one? So for some recent development, some recent development. Sorry about that. So the legal specialist exam results, those were released a week after our last meeting. So those were released on March 27th to all applicants. So there were 399 applicants that sat for the exam. 286 of them passed. That would gave us an overall pass rate of 71.7% across all of the specialty area exams. That is in line with our past administrations. 2023 was 74.8. 2021 it was 71.1 again. And then in 2019 it was 72.6. So with 71.1, I think that's really close to average of what we've been seeing in past exams. For the May 2026 Board of Trustees meeting, the proposed privacy law standards were adopted with an effective date of January 1, 2027. I really just want to say congratulations to the CBLS and the members. This is our first new area since 2008. So appreciate everyone's time and work on that. So with the effective date of January 1, staff were working with IT to launch the certification application by January 1. And then we hope to launch the exam registration application in 2029. And then the recertification application wouldn't need to open until 2032. Assuming people get initially certified next year, they wouldn't have to recertify for 5 years. So it gives us some time to work on that application. And the update on the RFP for the 2027 legal specialist exam driver. Just as a reminder, at March meeting, the CBLS approved the business requirements for delivery of the legal specialist exam and the rubric for assessing vendors. The RFP opened on April 20th and then it closed on June 4th. 2 vendors did submit proposals. So staff, along with our officers and our IT, have reviewed those proposals, and we are hoping to award the contract soon. We'll make sure to send an update to the CBLS about who that vendor is once that's done. Last, the update on the process for identifying and evaluating potential new legal specialty areas. If you remember back in December, the CBLS approved the process for identifying and assessing new specialty areas. We would like to bring this process to the Board of Trustees at their September meeting. We just want to confirm with them the level of proposed input and information coming from the CBLS to the board, just so that they don't feel like there's any surprises about if we're going to be moving forward with any new consulting groups or moving forward with any specialty areas. We just want to make sure that they're okay with the level of comfort and the level of information. Just as a reminder, per the process identified back in December, we would just inform the board of the CBLS's intent to move forward with consulting group. The board, they may say that they would want to see the recommendation and then provide input to the CBLS whether or not to do that. So we just want to let the board know just to see if they're okay with that. Anyone have any questions on any of these? Yes, Ms. Bennett.
Hey, just had a quick question. Do we have a specific budget for the vendors?
We haven't submitted the budget yet. But they did submit pricing. Yeah, so part of their proposals, we did request that they gave us their pricing estimates for licenses, for building the actual exam, for staff support on exam day. They were asked to price everything out. And then pricing would be considered as part of the review. Any other question?
Okay. I don't think there are any more questions on that.
Thank you, everybody.
Okay, so we move on to the next item, the update on identification and solicitation of exam development and grading subject matter experts for each legal specialization area. And I'll turn this over to Janelle.
Hi, good morning, guys. So our recruitment for the 2027 legal specialist examination roles, we kind of took a different turn with that. So this slide is going to provide an update on the staff's recruitment efforts for the 2027 legal specialist examination roles and cycle. So staff sent a recruitment email to 4,528 certified specialists to identify the individuals interested in participating in the upcoming examination cycle. The outreach asked certified specialists to indicate whether they were interested in serving as an exam developer, pre-tester, grader, or in any available role. So based on those responses received, staff identified the following interest levels. We got 117 certified specialists expressing interest in serving as exam developers. We have 58 certified specialists expressing interest in serving as pre-testers. We had 56 certified specialists expressing interest in serving as graders. And then we had 29 stating that they will serve in any role. In this response, it provides staff with a stronger pool of potential participants to support exam development, pre-testing, and grading needs for the 2027 examination cycle. In the prior recruitment efforts, we've used the Specialization newsletter to announce opportunities. And while the new newsletter still remains a useful communication tool, the direct email outreach to certified specialists provided to be more effective for recruitment purposes. And staff continues to use direct outreach for future recruitment efforts and will continue considering other communication methods as needed to support participation as well. That's all I have. Any questions? Thank you. George, you're on mute.
Sorry, I had muted myself. So moving on to the business section. The first item is discussion of and action, if appropriate, on the changes to the legal specialization exam grading policy beginning in 2027. And Adrian will address this.
Sure. Thank you. So for today's discussion, staff, we are seeking to update the current legal specialist exam grading procedures, and also to create a formal legal specialist exam grading policy, similar to the existing policy that's been established for the bar exam. The proposed changes are instructed by the CBLS 2026 work plan and also informed by psychometric best practices, the standards for educational and psychological testing. I just want to check the participants real fast. We are a little early. I think we're okay to get started. We did ask our psychometrician to be present and available for any questions. I don't see him in attendance just yet, but if I do, I'll make sure to let everyone know. What led us to the discussion today, so results from the 2025 exam. Those were released earlier this year in March. This was the first exam where our new psychometrician, ACS Ventures, analyzed and scaled the scores for the legal specialist exam. While current processes have supported fair and reliable grading outcomes, ACS, they have identified opportunities to improve the overall efficiency and reliability of the grading process. Again, when he does get here, our psychometrician Chad Buckendahl from ACS Ventures, they offer research, design, programming, statistical, and psychometric consulting services. And Chad, has been engaged in psychometric work with the State Bar of California's Committee of Bar Examiners for the bar exam and for the first year law students exam for some time already. Again, so for today, we'll look at our current LS legal specialist exam grading procedures and policy, followed by recommended changes based on those psychometric best practices and testing standards. Any step in the current process where we wanted to bring for a policy discussion and consideration, it is going to be noted by a red asterisk while you're looking at those slides. I'm going to change. Just another reminder about the CBLS work plan. This was approved by the Board Executive Committee at their May meeting. It was the specific initiative to review legal specialist exam design, administration, and grading, and then consider exam design and grading modifications informed by psychometric best practices. Per the work plan, this was to be completed or is to be completed by September 26th. So today's discussion, we'll take back any notes, and then we'll bring it back in September for final review and approval, if any, by the CBLS. For the current legal specialist exam grading procedures and policy, we'll look at the legal specialist examination development and grading team, also the graders. We'll look at the current format, discuss calibration, grading, scaling, and then reappraisal. And then also the release of results and grading considerations. Reconsiderations, excuse me. For our ledge team, we do have 3 members. Each member is a licensed California attorney. They have extensive experience grading the bar exam. Each member was actually also served on the bar examination development and grading team. Our members, they're an expert in offering advice about grading in a fair and consistent manner. And then they do work with multiple graders to make sure that the exams are graded fairly across each exam. The only thing that I did want to note is that the ledge team, they are not subject matter experts in each of the assigned areas of law. So they do turn to the graders for the substantive questions within those areas. And then also, please feel free to stop me if you want to discuss any of these slides as well. For our graders, each grader is a certified specialist in the area that they are grading. They must disclose if they know anyone who may have taken the exam that they are going to be grading. Graders are assigned at least 1 essay question to grade, and they cannot grade a question that they drafted or even helped to develop. And then I wanted to note that only 1 grader is typically assigned to each question. However, there may be instances where a second grader is introduced to help grade that question. Maybe the first grader knows later finds out that they may have known an applicant. But in either instance, each individual applicant answer, it's only read once by 1 grader. Go to the next slide. For our exam format, the essay portion, there's going to be 8 essays. Those are scored by the certified specialist graders. That makes up 75% of the total score. We have the multiple choice question portion. That's 25% of the total score. There are no points no points are deducted for incorrect responses there. And then the raw score from the essays and multiple choice questions, they're scaled for a final score. And then this increases reliability in any exam grading process. Again, all grading is anonymous. So applicants, they are assigned a random exam ID number. Each book will contain the exam ID, tying the book to a particular name and bar number. And And our graders, that's the only contact information they'll see. They won't see the applicant's name. They won't see the applicant's bar number. However, if a grader lets us know that they may know an applicant, we'll ensure that they won't see that applicant's materials. If graders later recognize the writing or penmanship, they must immediately notify us. And then if we have enough graders, we may end up dismissing that grader completely to reassign. But if it is one of those smaller areas, we'll assign a portion of that grader's answer books to a second grader to complete the rest. Here, we want to make sure that the grading process is fair and consistent. So grader scoring should be based on application of the grading guidelines. The score should be a function of the knowledge an applicant has demonstrated. It should not be different based on whether a hard or easy grader scored the answer. The score should also not be based on drift. For example, as I was grading, I became easier or harder. I was going along. And then a score should not be based on a grader's personal standards or opinions. To help ensure this, our graders, they do meet with our ledge team to review our policies and the rubrics to ensure that grading is fair and consistent. Ledge team members, they will also monitor the scores as graders complete their grading assignments. In terms of scoring, each answer is graded out of 5 points, and points are assigned in 1-point increments on a scale of 0 to 5. To earn a grade of 1, the applicant must at least identify a few key issues with minimal discussion. If these criteria are not met, the answer will be assigned a 0. Graders, they evaluate answers and assign grades solely on the content of the response. The quality of the handwriting, spelling, grammar, those are not considered whenever graders are reviewing and assigning scores. At the calibration meetings with the ledge team, so before actual grading begins, graders, they receive general orientation by staff where the ledge team and all graders are present. Graders receive the exam questions. They'll receive the model answer, which is a criterion-based grading rubric, and 5 actual applicant answers, which will be used for familiarization responses. Graders, they'll identify the score that they would assign and discuss the rationale to create a shared understanding of the appropriate scoring standards. After reaching consensus on the familiarization responses, graders can begin their independent scoring of applicant answers. And then while they are grading, the ledge team member monitors the grading and may request recalibration or even regrading as needed. Going back to the rubric, I apologize. So our grading rubrics, they are put in bullet point format for ease of checking off key points. Applicants, they generally write answers in different formats. So having that bullet point format is easier to reference. We can go to the next slide. After all grading is complete, the raw essay and multiple choice question scores are scaled to account for the relative difficulty of the examination and to promote fairness in final results. Applicants may receive up to 5 points per each essay, which could give them a maximum of 40 points for raw essay points on the written portion. And then applicants may receive up to 75 points on the multiple choice question portion. Again, those are scaled so that the essays are worth 75%, and then the multiple choice questions are worth 25%. To pass the exam in the first phase of grading, applicants must have a total scaled score of at least 453 points. Applicants who receive a total scaled score of at least 440, but less than 453, they will have their answers reappraised and read a second time, and that's automatic. In reappraisal, the ledge team member will read and review all answers submitted by an applicant. And then after that second read, applicants, they will be given an overall pass-fail decision. So they're not going to get new scores. They'll just receive a holistic result. For the release of results and grading reconsideration, results are released on the second Friday in March following the legal specialist exam. And then since an additional review has already been conducted for examinations achieving scores within the reappraisal range, the CBLS does not accept appeals or requests for further reconsideration. And then we did add on this slide just State Bar Rule 3.116B. Results reported to applicants are final. Applicants are not entitled to receive their exam answers or to see their scores. And before we go to this, that really covers our current processes at a pretty high level. Any questions on any of those? No? All right, so we'll move on to our discussion portion to see where we do have some proposed changes. And I do see that Chad Buckendahl is in the attendee list. So if there are any questions for myself or for him, please feel free to let us know so that we can promote him. Be able to address everybody. So for future grading policy considerations, we can go to the next slide. For the existing process where each answer is read and scored by one grader, the recommendation is to introduce a two-grader model to improve score reliability. Reliance on a single grader can lead to reliability concerns and scoring variability caused by applying the rubric inconsistently. Maybe they're being too lenient or too strict, or they're applying it incorrectly. Having two scores for each answer increases the evidence supporting each score determination. And then also the CBLS can create additional policies to identify and address score variability. One concern here we have, though, is that having two graders, we may run into recruitment issues, especially as it relates to the smaller specialty exam areas. But we do hope to address this, and we do have it up for discussion in a later slide. We can go to the next slide. Introducing the two-grader model. How do we address score variation? Recommendation is to adopt a score variation policy. Such policy could be scores varying by 1 point or less between the two graders. They can automatically be averaged. And then scores varying by 2 points or more will require the graders to discuss and recalibrate. And then at that recalibration, the graders, they'll meet again with the ledge team to reach resolution on the final score. At that recalibration, again, we'll give the graders the familiarization responses, the rubric, and the answer where the variance was identified. Some resolution options may include requiring the graders to reach consensus. However, if consensus cannot be met, perhaps letting the ledge team be the deciding factor on that score. Or just letting the graders choose to update the original score or not, or average. Some other considerations, maybe we automatically average point differences of 2 or more, and then recalibrate on score differences of 3 or more. One thing to note here is that requiring recalibrations, it may create additional time needed to complete all grading for applicants. So again, when we release results in the second week of March, adding these new recalibrations, we may need to push that back. But any questions on this recommendation?
Can I ask, how close do we get to the deadlines for release at this point? Like, do we actually think it's going to push back release dates, or
I will
Or is
say
that speculative?
no. I mean I could say for the not including not 25, but 23 and 21, I feel like we were pretty close.
Okay.
And for 25, we did push it back 2 weeks.
Okay.
We notified applicants the week of the original deadline, um, to let them know that we were going to push it back 2 weeks. Couple applicants said thanks, but no applicants raised any issues or concerns with the notification. They were all fine.
Is there an idea of how much it would push back release dates if we were to take on some of these recommendations?
So in a later slide, I do think if we pushed it back 2 weeks again, I think we're fine. But I do have that in a later slide. Maybe 2 weeks is not enough, but any other questions? Thoughts? All right. For this one, so for the original process where graders are certified in the specialty area exam that they are grading for, we do want to recommend allowing other legal professionals to grade the legal specialist exam. So here we'll just call that a non-specialist grader because they're not. Again, this two-grader model, it may pose some recruitment challenges. Um, However, we could look at other professionals that include judges, law school professors, or even other certified specialists in other states. For example, at Admiralty and Maritime Law, that is one of the areas where we do typically have recruitment issues. Florida, they have the Florida Board of Specialization. They offer an Admiralty and Maritime certification. Maybe we allow those specialists there to grade our exam. And then also in 2019, we conducted a legal specialist exam grading study that compared specialist versus non-specialist graders. That study was attached to the agenda. It was conducted by our previous psychometrician research solutions group. In that study, almost all answer files were read and scored by two different graders. Within the study, we looked at having paid versus volunteer graders. For that part, we compared the reliability across exams. So 2019 results that had the paid graders was compared to the scoring of the previous four exams where those graders were volunteers. And then in that study, we also looked at specialist versus specialist graders. So we compared the reliability between exams that were scored by two specialists, again, grading in their certified legal specialty area. And then for the purpose of today's discussion, within that study, we looked at specialist versus non-specialist graders. So we compared the reliability of specialist grading in their own specialty area versus, I'm going to say another specialist because within the study that the second grader was a specialist in another area, but they were grading that same exam for that first grader. So in that study, the specialists graded their exam, and then we had the non-specialist graders reevaluate those responses that already received that first specialist grade, and then the consistency between the scores was analyzed. Any immediate thoughts, concerns, question? No. I take it that we're open to the recommendation. All right, we can go to the next slide. Some key findings from that study of the specialist versus the non-specialist graders. Non-specialist graders, they demonstrated relatively strong performance and showed general agreement with the certified specialist graders. Non-specialist graders were slightly less consistent in their scoring patterns. However, their lack of consistency was only slightly behind the levels between the two specialist graders when compared to those. Overall agreement levels suggest that the state bar can effectively incorporate graders from the outside when necessary. However, we also want to note that the study also suggested that inconsistencies can be further reduced through improvements to recruitment and training processes. Some recommended enhancements could be providing more comprehensive model answers that account for alternative but acceptable terminology used by the applicants, distributing grading materials in advance of training sessions, ensuring that graders are not required to work outside of their expertise unless they feel adequately prepared after training and studying further. Anyone have any questions on this? No.
How great was the variability between specialist and non-specialist graders, or how much of a difference?
Um, I'd have to pull up the specific report, but the conclusion from the psychometrician at the time was that it was minimal.
Okay.
Cool. Let's go next. Oh, Grace.
How many specialty areas might have a lack of enough graders? And are they, you mentioned Admiralty and Maritime, which I take as a federal law, so you could have people from other states, um, being able to do the grading and assessment. So I'm just wondering, I'm happy that the graders will be specialists in that field, but I'm wondering how many specialties there's a concern. I don't want to say concern, but this might affect.
I think within Janella muted herself, but within the last 5 exams, in any given exam, I think it was 4 exams total. And it may vary between each administration, but I think in any one administration it was just 4 exams. But you're right. I think it is. I think luckily it is those exams where there's federal law, so it's Admiralty Maritime. I think once we did have an issue with bankruptcy. Criminal federal has been one area that we've typically struggled in getting us graders, and then appellate criminal would be another area, and then legal malpractice is also one that's come up.
Thank you.
Of course. All right, we'll go to the next one. So one recommendation is to introduce a 2-grader model, both for usage and then also to conduct further studies. So here we'll introduce the 2-grader model for all exams. Exams that have 2 specialist graders, we can have both grades count towards the applicant's scores. For any areas that a second specialist cannot be recruited, we introduce a second non-specialist grader to collect the additional data for study. But for those exams, only the specialist grader's scores would count towards the applicant's score. And then those exams, those will follow our current grading procedures, the ones that I just went through in those earlier slides. And then CBLS can create additional policy to address and define non-specialist grader selection and eligibility. Any questions on this one? No? All right. The next one.
Right, Adrian, I
Yeah.
apologize. What is the extra data or what's the goal on these exams where we would have a non-specialist grading? Is it just data collection is to see consistency amongst graders?
Correct. Yeah, because we only did the
That's
study once,
Yeah,
and that was what? It's 26 now. 7 years ago.
got it.
Yeah. So we just want to, if where possible, get additional data just to ensure that the reliability between the 2 graders is still consistent.
Got it.
Yeah. And then here we'll go back to allowing other legal professionals to grade the exam. So the recommendation is to adopt a non-specialist grader selection and eligibility policy. For considerations, we want to make sure that those non-specialist graders, they have similar experience in the specialized area when compared to our specialist graders. So in California, in order to receive certification, specialists must have practiced in the area for at least 5 years. Maybe we have that same 5-year requirement for the judges or the law professors that they have been working in that area for a similar amount of time. We can also say that the non-specialist grader, they cannot take the exam if they've graded the exam in the last, I just threw a number, 5 years. That ensures that they're not immediately taking the exam with that, I want to say, finger quotes, insider knowledge about how the grades are scored. We do want to give some time between that. We also wanted to note that the non-specialist graders, they're only used when reasonable recruitment efforts are exhausted and are unsuccessful. And then also noting that the CBLS can re-review the policy in the future. Thoughts maybe, again, 5 years, which would be 2 administrations worth of data. Any questions on this one?
With 5 years, isn't that gonna really or limit the somewhat the pool of people applying to be specialists? I mean, 5 years to me seems a little long.
Oh, okay. I think maybe, what were you thinking then? Maybe just one exam? I don't know. Because
Yeah, I was thinking one.
because it is every other year. You're thinking like one
Yeah,
exam
I was
administration?
thinking one exam.
Okay. Just note that. Cool. Grace.
Are the non-specialist graders from the pool of people mentioned earlier, I think it was judges, professors, or is it, I'm just wondering,
Those were just as an example.
okay.
Yeah, I mean, I think helpful if the CBLS has thoughts on the type of non-specialist.
I think it's just a common sense concern about having a non-specialist grade a specialist exam. Um, just that. And it sounds like this is last resort. So you know, just concerned about that. Who would what would the non-specialist pool look like?
I mean, we could definitely limit it. Maybe just in terms of discussion. Does everyone feel okay? Like if a judge was brought in to grade, I saw George nodding.
Yes.
Or yeah, um, law professors.
Yeah.
Yes.
Yeah. What is it? Specialists from other states.
Yes.
Okay. Yeah, so I think we can definitely target to the am I missing something? I mean, we could of course open it up to general practicing attorneys who are not certified, as long as they indicate that they've been in the area, but it seems like that maybe not something the CBLS is comfortable with.
Correct.
Okay.
For me, at
Uh,
least.
cool. I'll leave it at these 3 for now. And then again, we'll put this together in a more formal item and policy, and then when it comes back in September, if the CBLS feels different about anything, we'd also be able to change it at the time.
Yeah.
All right. For the current process of the ledge team monitoring grading, and then requesting recalibration or regrading as needed, excuse me. The recommendation is that staff will monitor all grades, and follow up with graders and ledge team based on the any new score variation policy. So if a new policy is adopted, the ledge team, they will not need to monitor the grades because those graders will just have to recalibrate automatically. But the ledge team will still lead those recalibration sessions. The only caveat is, again, for those smaller areas where there's one specialist grader, in those instances, the ledge team will still continue to monitor those grades. So this would apply only for the 2 specialist grader model. Questions from anyone? Nope, nope. All right, we'll move to the next. Applicants who received a total skilled score of at least 440 but less than 453 points automatically go to reappraisal. Again, this is just for the 2 grader model. Recommend eliminating the automatic reappraisal process. With the 2 grader model, it provides a method to collect evidence demonstrating that the rubric is applied consistently and the resulting scores are reliable. And then also having that requirement of graders needing to recalibrate and discuss demonstrates, again, that the rubric is being applied consistently and that any variance is going to be addressed. And then I also just wanted to note that the impact of this decision will be small. Before I ask for any questions, I'll go to the next slide. Here we look at the last 5 exam administrations. And then we can see the total number of applicants that received reappraisal within each exam. And then the total number of applicants who passed after reappraisal after each exam. So in 2025, only 2.2% of all applicants passed after reappraisal. In 2023, it was just 1%. In 2021, 1.75. And then 1.9. And then, 2017 was a little high, but I think on average, it's just 2.3% of applicants. So again, if we are removing the reappraisal procedure, the impact would be small to those applicants. Any questions on this?
Do we dissuade people from wanting to take the examination without the reappraisal, especially considering that they don't have access to knowledge about how much they failed or lost by?
I don't know. I don't necessarily know if applicants already knew ahead of time that there is a automatic reappraisal. I can't say, unfortunately. I don't know how they would feel or not.
I just say that's the only concern I would have, is that I assumed there was automatic reappraisal in line with kind of the way the bar examination runs. So that's kind of an assumption I made going into the examination, at least when I took it. So I would think, I don't know, considering that we're only talking about, 15 people in some years, 30 people in other years, even though it is a de minimis effect, I don't know. I feel like there's a morale level there of, hey, we do care. Hey, we are giving you a second chance, especially since we're not giving them access to the exam after the fact.
Okay.
Just a thought.
Any other questions or thoughts or concerns on this? Grace.
I was just I know we've talked about this in other meetings, but just it struck me. So has the total pool of applicants gone down? So that much?
It has been trending downward.
Okay. Thank you.
Unrelated to this, one of the initiatives is to increase outreach on the work plan. So hopefully we can bring those numbers back up. Any other questions on this slide or the previous? All right, go to the next one. For the current process, that results are released on the second Friday in March. The current recommendation is changed. So on the second Friday in March, that's 19 weeks after the administration of the exam. We are recommending to push that back to 21 weeks. Again, the operational impact of a 2-grader model and automatic recalibration may require additional time. If grading is completed sooner, we can always release the results at that time. And then also the CBLS can reevaluate timing and adjust the release schedule for future exam. Just as a reminder, or maybe new information, but the release of the results, it isn't set by any rule or policy or guideline currently. It's just always typically been done on that second Friday. And then again, we did change the results at this last exam. And it didn't seem to concern the applicants that much. So I think if we push it back 2 weeks, I think we're comfortable. But then again, Dana raised it. Do we really think 2 weeks is enough? Maybe it's something we'll take a look at. But again, I don't know. Maybe if Chad, I can bring him on. The hope is that graders are scoring reliably and consistently, that we wouldn't need to recalibrate. I don't know if I can bring back to see if there's any data on other exams on the variance between graders and how many actually need to be recalibrated. But the hope is that, or the thought is that, as long as we're providing the additional training, we're enhancing the training, that there would be consistent grading across between two graders. So, any questions? Anybody? Let's make a note real fast. All right, we'll go to next slide. So with those changes, the proposed new grading policy would maintain the current practice of conducting a mandatory orientation and calibration meeting with the ledge team, where additional calibration meetings may be scheduled as needed. Requires that each written item response be assigned to two graders, receiving two assigned scores, as opposed to the current model that's only one grader, one score. In instances where a second grader cannot be recruited, allows for other legal professionals to grade answers to further study the specialist versus non-specialist grading. These exams would be scored by current process in the one grader model. We would continue the current practice of assigning scores in 1 point increments on a scale of 0 to 5. And then it would change the release of results from 19 weeks to 21 weeks after the administration. And then we'll continue on the next slide. So for those exams where there's only one specialist grader, it'll maintain that every answer is read at least by one specialist. Only applies if the second grader is non-specialist grader. Requires that only the specialist grader scores are used for applicant scoring. Maintains ongoing ledge team review of score distributions during the grading. Maintains recalibration and re-review of scoring when requested by the ledge team. And then this model maintains the automatic reappraisal for applicants who receive a total skill score of at least 440, but less than 453 after the first read. And then for the two specialist grader policy, continue the next one. Here I highlighted these. Again, depending on discussion or thoughts, these can be changed, but requires averaging the two assigned grades for each answer if there is a difference of 1 point or less after that first read. Requires the two graders to recalibrate with the ledge team and discuss the assigned scores if there is a difference of 2 or more points between those two graders. Following discussion, the two graders will reach consensus to determine the final score. With the automatic averaging and recalibration process, remove the ongoing ledge review of score distributions and subsequent re-review, and then also removes the automatic reappraisal process. And then just related to in terms of thinking about budget and money related to this, although minimal, staff, we do expect cost savings related to the ledge team no longer monitoring or conducting reappraisals. And then also any costs related to second graders would be offset by the recent increase to the legal specialist exam registration. Just as a reminder, I don't remember if everyone knew, but the exam registration costs it went up quite a bit. So we do expect that any additional costs related to grading would be offset. So, and that brings me to the end. Are there any other questions, thoughts, or concerns for us as we prepare this? Ms. Bennett?
Hey, it's just simple. I was going to ask you what was your definition of the word drift, DRIFT. I looked up the definition and it just says to move it along. But did you have a different definition of how you were going to use it when it came to the grading process? Must be fairly consistent.
I'm going to allow Chad. I believe that there's a specific psychometric definition related to drift.
Hey, Adrian.
Hey, Chad, were you able to catch that question?
Yes, regarding the
Drift.
interpretation of drift.
Yeah.
Yeah. So, excuse me. Um, Raider drift is when the raider moves away either higher or lower from what the intended scoring expectations are from the scoring criteria or the scoring rubric that's being used for a question. So you sort of train and calibrate to a specific interpretation. And when they move away from that, that's what creates some of the inconsistencies. So they're kind of drifting from shore or their anchor.
Thank you.
Thank you, Chad. Any other questions? Great. All right. Again, I'll take a look at my notes, and then we'll prepare this for September. And then we'll also have a draft of that formal policy. And then if there are any other thoughts or changes, we'll also be able to make it at a time before taking any action. So I appreciate everyone, your questions and your thoughts on this. So.
You're on mute, George.
I apologize. Moving on to the next issue is the potential new specialty areas in personal injury law and consumer law, and this be presented by Janelle.
Hello, everyone. So the purpose of today's discussion is to provide the CBLS with additional findings related to the potential development of a new specialty area, and this receive feedback on whether further research, outreach, or engagement is needed before staff proceeds with any next steps. So at the December 2025 meeting, staff walked you through the current process for recommending a new legal specialty area. As a reminder, the CBLS is still in the proposal area. And the staff continues to engage with stakeholders and other bar associations to gather information needed to determine whether to move forward with the proposal to the Board of Trustees for further exploration. So staff is also currently compiling its findings to develop a recommendation for the CBLS to consider whether to make a recommendation to the Board of Trustees, and if the CBLS believes there's sufficient information to narrow the scope at today's meeting, a motion could be made. If additional information is needed, staff requests direction on any further research for the committee would like to conduct, and will return with the recommendation at the next CBLS meeting. So for today's purpose of today's discussion, I want to present the additional findings. I want to provide the additional findings. Staff will walk through those findings related to jurisdictions, attorney organizations, and practitioner input, as well as any information that may help inform whether a further consideration of a new specialty area is appropriate. In addition to presenting those findings, staff is seeking CBLS feedback on whether there are any areas where any additional research or stakeholder engagement may be needed. This may include identifying specific organizations, practitioners, or subject matter experts who could provide further insight. And staff is also requesting guidance from the CBLS to help with to inform us on our possible next steps. So, depending on the discussion today, next steps may include continuing research, narrowing the scope of review, conducting additional outreach, or preparing a future recommendation for the CBLS consideration. But finally, staff will raise additional items for consideration, including the workload, the timing, the implementation concerns, and how any future work on a new specialty area may overlap with the implementation of the newly improved a privacy law specialty area. So at the last CBLS meeting, staff identified several areas where additional research or engagement was needed. And the following slides provide updates on those areas outlined in red and identify whether further outreach or engagement may be required. So here we take a look at whether, since the last CBLS meeting, staff conducted additional outreach with other jurisdictions and outside organizations for further assess to two application standards. And the first application standard asks whether other jurisdictions, professional organizations, practice sections, committees, or other entities specifically represent attorneys practicing in the proposed specialty area. And then the second one we have here is the standards asks whether any entities already offer a certification program in the proposed areas and whether those entities may be eligible to become an approved certification entity under Rule 3.903. So we consulted with the Texas Board of Legal Specialization regarding both privacy law and consumer and commercial law. So Texas explained that it evaluates their new specialty areas through a personal injury law. Just excited about privacy, sorry. So staff we spoke to Texas and they explained that they work through a public protection framework while CBLS appears to focus more specifically on individual consumers, access to justice, and people law. Texas also considers whether attorney groups can demonstrate the need. They provide the support from at least 100 attorneys and commit to advisory and exam development work. Texas also assesses both the public need and the program feasibility before moving forward with a new specialty area. And the Texas noted that most applications from a new specialty areas are received from the state bar sectors. So the personal injury, when spoken to, Texas noted that the area is broad and some attorneys may practice in areas that are too niche to meet the general certification requirements. And then Texas also noted that consumers may initially find personal injury attorneys through advertising, but certified specialists are often selected once leads are referred to the practicing attorneys. There are approximately 6,800 certified specialists, where that is including about 1,050 certified specialists in the personal injury trial law, which represents roughly about 15% of all certified specialists. They also seen a decline in this area because many cases resolve through mediation and other alternative dispute resolution processes and make trial-based requirements more difficult to meet. And then based on this information, staff believes additional outreach with California personal injury practitioners may help how to inform a potential specialty area should be constructed for that. We'll move to consumer law. For consumer law, staff conducted outreach with outside organizations and counsel on consumer law, including HERA and Consumer Law Unit and the Community Legal Aid of SoCal. These organizations express general support and interest in furthering exploring consumer law as a potential specialty area. They also, as Texas reported, limited participation in consumer and commercial law certification. Texas also noted that the few attorneys appear to practice exclusively in consumer and trade-related matters. Some attorneys practicing in this area may already fall under the civil trial law certification that we offer, and then also further research, including outreach to the National Board of Trial Advocacy or similar organizations, may help determine whether consumer law overlaps with our existing certification areas. Just another consideration to take in, the Texas has greater visibility into continuing legal education opportunities because many are hosted through the Texas State Bar. And California may need further research regarding continuing legal education availability, practitioner interest, and organizational support for both personal injury law and consumer law. Staff may also assess whether California attorney organizations or the practice groups can support outreach, continue legal education, and subject matter expertise. Is there any questions on this slide? Yes, Lisa?
I have a question. Why was just Texas reached out to as a state?
We reached
For
out to
feedback.
others, but unfortunately, no one has gotten back to us within that time.
Okay.
But I can continue more outreach on these two areas if needed. Pamela?
I was gonna, when you were talking about California or any other state in terms of participation, has the Beverly Hills Bar Association specifically been reached out to in terms of participation in their responses around personal injury or consumer?
I have.
And then lastly, if you're considering Texas or Florida, why not Virginia or New York or Oregon as a consideration?
So I reached out to a lot of the organizations that only offer personal injury law or consumer law as a certification. So I did reach out to associations as well as other state legal specialization. Texas was one of the ones that was able to get back to us at the moment and speak to us within that time, as well as those following organizations, housing and the economic right advocates, the consumer law unit, and as well as the community legal SoCal. So we can work with getting some more information if that's where the direction is after this presentation, to bring more information back to you guys to make a justified decision on where we should go with making a specialty area in this. Lisa? Lisa, your hand's still raised. Do you have a question for me? Thank you. So one of the questions on the application that suggests is consumer challenges. So the consumer law issues often appear as everyday financial or a marketplace problem. So consumers may not be recognized them as legal issues. Consumers may not know that a consumer law attorney can assist with matters involving the debt, fraud, credit reporting, billing disputes, scams, contracts, auto sales, and any unfair business practices. As well as consumers may also have difficulty determining whether this issue is serious enough to require legal help. Even when consumers seek help, they may not know how to assess whether an attorney has actual expertise and competence in consumer law. The State Bar's 2024 Justice Gap study found that Californians, sought legal help for only 18% of their civil legal problems and did not receive any or enough legal help for 85% of those problems. So Pew reported that consumers in debt claims typically have legal representation in fewer than 10% of the cases, and more than 70% of the debt collection lawsuits is available in available jurisdictions and in default judgments. Also, these findings support the concern that consumers may struggle to recognize consumer-related issues as legal problems or identify qualified counsel. And a formal consumer law certification could provide a clear pathway for the public to identify attorneys with demonstrating knowledge, experience, and competence in the specialty area. So our access to justice slide, one of the questions that we were looking for, questions to be answered was certification in the specialty area may improve access to the legal services. So consumers often do not know where to turn when dealing with issues such as debt collection, credit reporting, unfair business practices, scams, and such. And they would create a more reliable pathway as well. Um, for example, a consumer who receives a debt collection lawsuit may ignore it because they do not understand the process that was told, and it's easier access to a certified consumer law attorney may help that person respond before a default judgment and the wage garnishment or a credit damage occurs. A certified law certification problem would increase that confidence in pursuing available remedies. And the overall certification would support access to justice by making qualified legal help easier to find, as well as improving the public understanding and consumer rights and furthering the legal specialization program on public protection. So this one has a few red line stuff. So the application asks whether the law in the proposed specialty area is evolving rapidly. So when I spoke to other jurisdictions and such, as well as looked up some things for us to kind of take into consideration, it seems like consumer law appears to be evolving rapidly in recent legislative and regulatory activity, including the medical debt, overdraft fees, subscription practices, credit reporting, consumer lending, bankruptcy, mortgage servicing, student loans, automobile sales, and debt. In 2024, California enacted a consumer protection measures addressing medical debt, overdraft fees, and such. And then the National Consumer Law Center identified several consumer law changes taking effect in 2025 and in 2026. Including changes related to credit reporting, consumer lending, bankruptcy, mortgage servicing, student loans, automobile sales, and debt. When personal injury appears to be evolving in targeted areas, including medical malpractice damages, automobile insurance requirements, settlement practices, and the increase of use of mediation and other alternative disputes resolution processes. California's medical malpractice framework was modernized through the changes to the MICRA, including increasing to the non-economic damages cap over time. There has been a minimum automobile liability insurance limit increased in 2025, and such. So the second question asks whether there's any additional value to the certification and specialty area could provide and consider benefits to the public, legal profession, or justice system. When the question was addressed for consumer laws, certification may assist consumers again in identifying attorneys with demonstrating competence, and getting law matters situated at an earlier stage and in more effective manner. And this could help reduce escalation of consumer disputes, provide clearer guidance for self-represented consumers, and support broader access to meaningful legal assistance in the area that affects many Californians. Um, and then I felt like, as for that question to be answered for personal injury law, we'll need additional research and engagement in order to provide that information to you. Any questions? Go ahead, Pamela.
I'm gonna say yes, only because prior work with the Legal Services Trust Fund Commission, they had over 100 grantees throughout Southern and Northern California. And I was wondering if those um, agencies were tapped into in terms of their numbers for personal injury law and consumer law, and if they had any clients that needed that service.
I have not, but if you have a list of places that you feel that I can reach out to get some more information for personal injury law, I would really appreciate
Okay, I'll
getting those to
do
me if you
that.
can.
Thank you, ma'am. I'll do.
Thank you. And as I stated, additional information for such will be researched. So for the interest and support, I felt like the evidence for the current practitioners support creating a certification in the specialty area, and the opposition for concern for personal injury will definitely need some additional information. When I spoke to the following organizations, um, they felt like it was needed, something that would the express general support and interest in furthering exploring consumer law as a potential specialty area, and staff did not identify any opposition or concerns regarding the consumer law. And further engagement may help determine whether there is a broader practitioner support and sufficient infrastructure to support development of the specialty. So today, our discussion for guidance from the CBLS, we're seeking guidance on whether the consumer law or the personal injury law should be explored further as a potential new specialty area, and whether additional research or outreach is needed before staff proceeds. As CBLS considers the next step, staff would like to note the implementation of the newly approved privacy law, a specialty area. This will require a significant amount of staff time and program resources. This includes launching the application on January 1st, the processing of the initial certification applications with exam to pathway requirement, recruiting exam developers once those have been approved their certification. Then we can go ahead and begin the development and recruitment for those, and pre-testing of the questions, and then the launching of the recertification. And also preparing for the first privacy law examination, which is anticipated for October 2029. Because privacy law implementation is expected to continue through October 2029 examination cycle and potentially beyond, staff wants to ensure that the CBLS considers the potential overlap with developing another new specialty area, as well as if the CBLS does decide to move forward with any one of these areas, the Board of Trustees needs to support that direction. So we would have to kind of bring it back to them and let them know where we are with that proposal, to involve engaging a consulting group. So we would like to consider whether a delay for the further exploration until the legal privacy law is implemented, recommend a new specialty area, or as well as continue exploring this matter further for our next CPLS meeting. Go ahead, Grace.
When does staff recommend starting the overlap, I guess? Like what's reasonable? Because we don't know your
Adrian?
bandwidth.
I would imagine we would start development of a new exam ideally by March of next year. I can't say for sure because we don't know. I guess we have an idea of that people would apply, but I guess it's dependent on how fast those applications are approved, and even if they're interested in helping to develop the exam. But ideally, if we could start development in March, and then that would put us through to 29 even, but just something to consider. I don't want you to think that we can't do this, but it's just a consideration. So good.
No.
Oh,
Go ahead, Dana.
I'm kind of given the statistics and the outreach that you've done, I tend to think at least moving forward with privacy law, or not privacy. You keep saying privacy.
Sorry.
It's a hot topic word today. Moving forward with personal injury really does make sense. It seems like there's a good framework out there. It seems like it's the most consumer focused over consumer law, ironically. And I think there's already good infrastructure. I know Texas is the only one that responded to you, but I do know their board of specialization actually runs pretty similarly to ours. So I wouldn't be surprised if we'd be able to utilize a lot of their resources in order to create our own board. And to me, I don't know that the overlap is a big deal. This is implementation is all far away anyway. There's certainly some level of research to finalize that's going to happen, but it seems like personal injury is right there. It's ready and it's available.
George, I seen you had your hand up.
Yeah, I agree with Dana. Although I'd like to see a little bit more information. I don't know how we gain that on the interest of practitioners, just to make sure it's going to be viable.
Is there anywhere that you feel I should reach out to as well for that you guys are aware of, that you guys may share with me today, or after this meeting with an email that we can bring back for a possible decision at our September meeting on this?
Mm. I think that we should try to develop a proposal, but put that off until the December meeting, because you're dealing with the privacy law specialty. And I think that's a lot of workload, but to give you a little bit of additional time.
So you would like to bring back this for a recommendation to the CBLS to make a determination at the December meeting?
Yes.
Perfect. We'll note that. Thank you for your guys' time.
Okay. And are there any other questions and comments on the previous discussion? Okay.
Go ahead, Lisa.
I just have a quick question. I agree with Dana about moving forward with personal injury, but I just had a question. A lot of times for the public, they only hire an attorney at one of the most vulnerable times of their life when they have a major accident or something. I know ABA just addresses the truthfulness in advertising, but I wondered if for specialization, will we look at the unsavory practices of advertising and go a little bit farther instead of just addressing just truthfulness, whether or not that billboards or anything just have to, or there has to be some kind of disclosure that these attorneys need to be certified in this area? That was my concern.
I'll take note of that and make sure to look further into that matter.
So the next item is our discussion and action, if appropriate at this time, on the standards for certification, recertification, and workers' compensation law. And this will be presented by Mia.
Yes, good morning, Chair, members of the board. Thank you. I'm here to present a brief to the CBLS on staff's review of the workers' compensation standards and seek direction on next steps. As you know, the CBLS work plan calls for a review of certification, recertification process, and standards across specialty areas. Staff initiated a phased review and identified workers' compensation as the first recommended area needing evaluation. We focused on workers' compensation specialty area because it showed a disproportionately high number of escalated applications. And when I say escalated applications, I mean applications that were submitted that do not meet the minimum required task and experience level. Thank you. Thank you, Janelle. Since 2019, workers' compensation has processed a total of about 1,400 new or initial recertification applications. And so that's about 20% of all applications. But they make up nearly 50% of all escalated applications, so about a total of 239. And as you can see from the chart, other specialties show much lower escalation rates, even with similar or lower application volumes. So this imbalance for staff suggested that the current standards may not reflect current workers' compensation practice. We did conduct preliminary consultation with two working group members, the two workers' compensation working group members. Both members agree that the core subject areas remain appropriate. And you can change to the next slide, Janelle. And the one after that is good. However, several quantitative requirements, especially in the area of trials and appellate tasks, no longer match what the current practice patterns seem to be. They noted practice has shifted towards more remote proceedings, many cases resolved without trial. Trial-related requirements may be unrealistically high. They also noted appellate-related tasks occur infrequently and may be concentrated in more specialized departments. And then focusing on the actual standards, the recertification language in Section 4 of the standards, they note, is vague and may need further clarification. So both members did support updating requirements to reduce any unnecessary escalations. So very briefly, staff recommends moving forward with a review and revision of the workers' compensation standards in this area, but seeks CBLS's direction on if you agree and any additional areas for consideration. And those are my final remarks. I'm happy to take any questions or yes. Yes, George.
Yeah, I agree that there are not that many trials in workers' compensation. A lot of the cases do settle. There are even fewer appeals. I think my one comment is that out of 10 trials in workers' compensation, we have 3 different types of hearings. A priority conference on issues of causation where a case is denied. We have expedited hearings on issues of benefit payments and evaluators, and then just normal trials and all issues. And so I think of the number of trials within that period, that there should be at least one in each of those types of trials, given that there are 3 different types. So that they would have to show that I've done at least one of these types. That is, that they've done all 3 of those within the total number.
Okay. Yeah, the current standards just indicate total number of 20 trials to submission. But it doesn't, the language says it includes expedited hearings.
Mhm. Mhm. It should include priority conferences on denied cases where causation is an issue. But beyond that, I'm comfortable with changing the recertification and certification standards.
Yes, I see Lisa's hand raised.
I have a question. Could you explain what escalation application means?
Sure. So normally, whether it is a initial application or an application for recertification, once it's submitted, the application has basically a check the box, and if you've met the minimum requirements, you've so checked that you have accomplished the 20 trials or the 5 appellate hearings or the one, I think it's 10 depositions. But if you are not checking one of those boxes, then there is another part of the application where you could submit information on that you've substantially complied with the minimum standards in another way. So it's more of a narrative explanation of what you've done in your practice area. And so sometimes and so once that information is submitted, then it goes at the basic staff level, cannot be approved. It's escalated to supervisor review, and we oftentimes use the working group members to review that experience level to see if it's in compliance, so really substantially compliant with the standards. So I hear from George. I think George, you mentioned that you're okay changing the standards. Does the group recommend that the staff return to the working group and prepare recommended changes to the standards for initial certification and recertification level, and then at some point in the future we can return with those recommendations to the board?
That's what I recommend, that we move forward and get something more formal.
Okay. We do have 2 current working group members that we working with. I do know that they are both in Southern California. We will, I think, just for some geographic diversity, try to seek out someone Central or Northern California for an additional input in this area, but we can certainly move forward.
Okay.
Thank you.
Mhm. Are there any other questions or comments? Okay. So that ends the open session items. I don't believe there's any closed session business. I'd like to thank everyone for attending. The next meeting is scheduled by Zoom again on September 11th of this year at 10 a.m. And the current time is 11:43, and the meeting is adjourned.
Thank you.
Thank you
Thank you,
all.
everyone.
All right.
Thank you.
Thank you.